I'm Alexander Sterling, and I've been practicing estate planning and probate law in California for over 15 years. You might think my job is mostly about wills, trusts, and helping families plan for the future, and a lot of it is. But sometimes it's about picking up the pieces when that trust is shattered into a million fragments, often by the very person appointed to protect a loved one's legacy. One such case still sends a chill down my spine, even years later. It's the story of an executor, a man seemingly beyond reproach who systematically siphoned over $800,000 from an unsuspecting family's inheritance. My client, Maria, walked into my office a year after her mother's death. Her eyes hollow, her spirit crushed not just by grief, but by a gnawing suspicion that something was terribly wrong. She knew deep down that the family friend appointed as executor, a man who had even been a pallbearer at her mother's funeral, was hiding something. But the sheer scale of the betrayal, the audacity of the theft, was something none of us could have imagined. What was at stake was not just Maria's inheritance, which her mother had meticulously planned for, but her fundamental belief in decency and trust. The executor, Robert Harrison, wasn't just managing the estate. He was dismantling it piece by piece for his own illicit gain. His actions weren't merely negligent. They were a calculated, cold-hearted betrayal of a deceased friend and her grieving daughter. And it took a deep dive into bank records, a relentless forensic accountant, and a dramatic courtroom showdown to reveal the shocking truth and bring him to justice. Here's what you need to understand about the legal framework governing executors, because it's the foundation upon which this entire betrayal was built. Under California Probate Code, Parv 8400, when a person dies with a will, the court appoints an executor to manage their estate. This executor, often a family member or a trusted friend, steps into a powerful role. They become a fiduciary, which is a fancy legal term for someone entrusted with holding assets for another person. This fiduciary duty, as outlined in California Probate Code Parv 9601, is one of the highest duties recognized by law. It demands unwavering loyalty, honesty, and transparency. An executor must act solely in the best interest of the beneficiaries, managing assets prudently, paying debts, and ultimately distributing the inheritance according to the will. They are legally prohibited from self-dealing, from using estate assets for personal gain, or from commingling estate funds with their own. Think of it like a sacred trust. You are holding someone else's life savings, their dreams, their future in your hands. You are sworn to protect it. When an executor breaches this duty, whether through negligence or outright theft, it's not just a financial misstep. It's a profound violation of that trust, and the law provides severe penalties for it. This is why this case was so critical. It wasn't just about recovering money. It was about upholding the sanctity of that fiduciary bond and protecting the integrity of our legal system for those who are most vulnerable, the bereaved. Maria Rodriguez was a quiet woman, an elementary school teacher in her late 40s. When she first walked into my office, her shoulders were slumped and her usually kind eyes, accustomed to the bright innocence of children, held a deep, weary sadness. Her mother, Elena, had passed away a year prior on January 15, 2022, after a swift battle with cancer. Elena had been a vibrant woman, a small business owner who, along with her late husband, had built a comfortable life. She left behind an estate valued at approximately $1.5 million, primarily consisting of a modest family home in Orange County, a diversified investment portfolio, and a substantial sum in various bank accounts. Elena's will, carefully drafted years before, named Robert Bob Harrison as executor. Bob wasn't just a casual acquaintance. He had been a fixture in their lives for decades. He was a longtime family friend, a golf buddy of Elena's late husband, and even a board member on Elena's small consulting firm. He projected an image of quiet competence and trustworthiness. When Elena passed, Maria found comfort in knowing that Bob, this pillar of the community, would handle her mother's affairs. He was officially appointed executor by the probate court in March 2022. Initially, Maria didn't worry. Bob was busy, he said, but he was working on things. He mentioned some administrative costs and executor fees that needed to be paid. But as months turned into nearly a year, the initial explanations began to wear thin. The distributions Maria expected, which her mother had promised would secure her own future and help her pay off her student loans, never materialized. Instead, there were vague assurances, promises of imminent action, and then a chilling shift in Bob's demeanor. By October 2022, when Maria gently inquired about the status of the estate's funds and asked for an accounting, Bob became evasive. He'd suddenly be too busy for calls or send curt emails dismissing her concerns. By December, his responses were tinged with thinly veiled hostility, implying Maria was being ungrateful or impatient. He told her she didn't understand the complexities of probate and that she should just trust him. Maria naturally started to feel a profound sense of unease. Her grief over her mother was compounded by this new anxiety. She felt guilty for questioning a family friend, yet a gut feeling screamed that something was terribly wrong. She eventually found me in February 2023, referred by a colleague. She sat across from me, her hands clasped tightly, whispering, "Mr. Sterling, I don't know what to do. I just want my mother's wishes honored. And I don't think Bob is doing that." Her vulnerability, her raw grief mixed with a dawning fear, made it impossible for me to turn her away. I knew then that we had to get to the bottom of it. My first step, as always, was to obtain the public court filings in the probate case. This initial review raised immediate red flags. While Bob had filed an initial inventory of assets, many of the distributions seemed vague, lacking the specificity typically required. More concerning were several large withdrawals from the estate account labeled simply as executor fees or administrative expenses, totaling nearly $150,000, without any corresponding court approval for such sums. Executor fees are subject to court oversight, and those amounts were far in excess of what would be considered reasonable or legally permissible at that stage, without a formal petition. This immediately put us into an intensive investigation phase. I promptly issued subpoenas for all bank statements related to Elena's estate accounts, her personal accounts, and critically, given the discrepancies, Bob Harrison's personal bank and investment accounts. This wasn't a fishing expedition. It was a targeted effort to follow the money. I also brought in a forensic accountant, Sarah Chen, a sharp, meticulous professional known for her ability to unearth financial malfeasance. Sarah's specialty was peeling back layers of financial transactions to reveal the truth. We also engaged a private investigator, Mike Riley, to conduct some discreet asset searches on Bob, just in case he was hiding any ill-gotten gains. The early weeks were frustrating. Bob's attorney, Thomas "Tom" Miller, a known aggressive litigator in town, immediately tried to stonewall us. He fought every subpoena, claiming invasion of privacy for Bob's personal accounts. But I argued forcefully to the court that Bob's personal finances were directly relevant given his role as a fiduciary and the suspicious withdrawals from the estate. Judge Vance, seeing the clear pattern of evasiveness, agreed with us. As Sarah and I dug deeper, the picture grew darker. Sarah methodically cross-referenced the estate's bank statements with Bob's personal accounts, looking for unusual patterns. The first major piece of evidence to emerge was a series of large, round-number transfers, $25,000 here, $50,000 there, from the estate account directly into Bob Harrison's personal checking account. These transfers, sometimes labeled executor advance, often had no supporting documentation or court approval. They added up quickly. Then came the really disturbing discoveries. We found records of Bob using what were clearly estate funds for lavish personal expenditures. There was a $75,000 down payment on a new ski boat registered in his name, a $30,000 payment to a luxury travel agency for a European cruise, and tens of thousands spent on high-end home renovations at his personal residence in Laguna Beach. These were not modest expenses. These were clear signs of an unchecked spending spree fueled by Elena's inheritance. But the most damning evidence came in the form of a series of checks. Sarah identified 10 separate checks totaling approximately $120,000, written out to cash or obscure shell-like vendor names, all dated after Elena's death. The signatures on these checks purported to be Elena Rodriguez's. However, compared to known samples of Elena's authentic signature on her will and other documents, these signatures were clumsy, shaky imitations clearly forged. Bob had taken advantage of the fact that Elena's bank account was still open and hadn't been immediately closed after her passing. He was systematically draining it, making it look as if Elena herself was still making withdrawals. This wasn't just a breach of fiduciary duty. This was grand theft and forgery, plain and simple. The sheer audacity of these acts, committed by a man entrusted with Elena's final wishes, made my stomach drop. We had found our smoking gun, and it was devastating. The breakthrough moment, the one that solidified our case beyond any reasonable doubt, came during one of our regular strategy meetings with Sarah Chen, the forensic accountant. We had been poring over mountains of documents for weeks, piecing together fragments, following digital breadcrumbs. The office was quiet, save for the gentle hum of the fluorescent lights above and the rustle of paper. Sarah, with her usual calm demeanor, handed me a thick binder. "Alex," she said, her voice betraying a hint of the gravity of her findings. "I've completed the full audit. It's worse than we thought." My heart raced as I opened the binder. Inside was a meticulously detailed spreadsheet, color-coded and cross-referenced, outlining every single suspicious transaction. Sarah had charted the flow of money from Elena Rodriguez's estate accounts directly into Robert Harrison's personal coffers. The transfers, the illicit purchases, the new boat, the European cruise, the home renovations, were all laid out with irrefutable clarity. The total sum was staggering, over $800,000 systematically siphoned from Elena's estate. But it was what came next that truly sent a jolt through me. Sarah then presented magnified images of the 10 forged checks, placed side by side with genuine signatures from Elena's will and other authenticated documents. The difference was stark, undeniable. Elena's genuine signature was fluid, confident, and consistent. The forged signatures were hesitant, shaky, and inconsistent, betraying the hand of someone trying to imitate. They were crude, amateurish forgeries, but they had initially slipped through the cracks. Sarah had even obtained bank fraud reports which showed these checks had been flagged by internal bank systems as potentially suspicious, but had been overridden and processed, presumably by an internal contact or by Bob exerting pressure. This wasn't just a misallocation of funds. It was premeditated fraud executed by the very person meant to protect the estate. This was the smoking gun. These forged checks, cleared after Elena's death, definitively proved criminal intent and demonstrated that Harrison wasn't just negligently managing the estate. He was actively stealing from it through deceit. The legal significance was immense. It transformed the case from a mere breach of fiduciary duty into something far more serious, carrying potential criminal charges for grand theft and forgery. I called Maria into my office immediately. As I laid out the evidence, showing her the charts, the transfers, and finally, the damning comparison of her mother's signature with the crude forgeries, her face drained of color. She stared at the images, her eyes welling up with tears. "He was family," she whispered, her voice cracking. "How could he do this to my mother, to me?" Her pain was palpable, a mix of profound grief, shock, and a searing anger that finally broke through her quiet resolve. But beneath it all, I saw a flicker of determination. She now had irrefutable proof, and she was ready to fight. The courtroom drama unfolded over 2 intense weeks in Department 17 of the Orange County Probate Court. Judge Eleanor Vance, a woman known for her sharp intellect and no-nonsense approach, presided with a stoic impartiality. The courtroom itself was a study in legal gravitas. Rich, dark wood paneling, high ceilings, and the imposing bench where Judge Vance sat, observing every nuance. The air crackled with tension, especially on the days Robert Harrison was present. His usually confident demeanor now slightly frayed, his eyes occasionally darting towards Maria and me. My star witness was Sarah Chen, our forensic accountant. She took the stand, calm and composed, and delivered her testimony with the precision of a surgeon. She walked the court through her audit, displaying detailed charts and graphs on the large screen, illustrating the systematic flow of $800,000 from Elena's estate accounts directly into Bob Harrison's personal accounts and expenditures. She presented the spreadsheets highlighting the specific dates, amounts, and beneficiaries of the illicit transfers. Her methodical, irrefutable evidence laid bare the financial deception. Opposing counsel Tom Miller then launched into his cross-examination of Sarah, attempting to discredit her. "Ms. Chen," he began, "isn't it true that financial analysis is often open to interpretation? You've merely interpreted these transfers as illicit, haven't you, rather than legitimate reimbursements or executor fees?" Sarah, unperturbed, replied, "Mr. Miller, my analysis is based on established accounting principles and verifiable bank records. The transfers lacked any corresponding court approval or legitimate invoices. Furthermore, the expenditures, such as the purchase of a speedboat and luxury vacations, are clearly personal expenses, not estate liabilities. There is no ambiguity in the financial data." Miller pressed on, but Sarah held her ground, her expertise unshakable. Then came the moment for Robert Harrison to take the stand. He projected an initial air of offended innocence, denying any wrongdoing, claiming the transfers were loans or reimbursements he was entitled to. His testimony was slippery, full of evasions and convenient memory lapses. It was my turn for cross-examination. I approached him, a thick stack of documents in hand, the forged checks conspicuously placed on top. "Mr. Harrison," I began, my voice steady, "you testified that the $50,000 transfer on April 15, 2022 was for executor fees. Can you point to any court order, any document at all authorizing such an exorbitant fee?" Harrison shifted uncomfortably. "It was an advance for my time." "An advance for your time," I repeated, "without court approval and without any accounting for the hours you supposedly worked, and this advance went directly into your personal account, not a separate estate account for fees, correct?" He mumbled, "I don't recall the specifics." I then moved to the truly devastating evidence. "Mr. Harrison, we've established that Elena Rodriguez passed away on January 15, 2022. Is that correct?" "Yes," he confirmed, his voice barely audible. "And you were appointed executor in March 2022, is that also correct?" "Yes." "Then can you explain this?" I walked to the overhead projector, placing a magnified image of one of the forged checks on the screen. It was dated February 1, 2022, signed Elena Rodriguez, made out to cash for $15,000, and deposited into Bob Harrison's personal account. I then projected a side-by-side comparison with Elena's authentic signature. The courtroom went silent. Even Judge Vance leaned forward slightly. "This check, Mr. Harrison, dated 2 weeks after Elena Rodriguez's death, bears her purported signature, and it was deposited into your account. Did Elena Rodriguez sign this check?" Harrison's face drained of all color. He stammered, I don't know. It must have been an old check. She might have pre-signed it. Pre-signed a check for $15,000 2 weeks before her death, and then somehow it got into your possession and was deposited after she passed? And what about the 9 other similar checks totaling $120,000, also dated after her death, with signatures identical to this one? Miller, his face pale, rose. "Objection, speculation." "Overruled," Judge Vance stated, her voice sharp. "Mr. Harrison, you are under oath. Answer the question." Harrison looked utterly defeated, his eyes darting to Miller, who simply stared at the floor. He swallowed hard. I can't explain it." "You can't explain it," I echoed, "because a deceased woman cannot sign checks. You forged these documents, didn't you, Mr. Harrison, to steal money from Elena Rodriguez's estate?" The question hung in the air, heavy and damning. Harrison remained silent, his shoulders slumping. His entire arrogant facade crumbled, replaced by the shame of a man caught in an undeniable lie. 2 weeks later, Judge Vance delivered her ruling. Her voice was firm, unequivocal. She found that Robert Harrison had engaged in a clear and egregious breach of his fiduciary duties, and, more significantly, had committed acts of grand theft and forgery. The outcome was a resounding victory for Maria. Judge Vance ordered Robert Harrison to be immediately removed as executor. He was ordered to repay the full $800,000 he had stolen, plus prejudgment interest. But the judge didn't stop there. Citing California Probate Code, paragraph 859, which allows for double damages when an executor has acted in bad faith or fraudulently appropriated estate property, she awarded Maria an additional $800,000 in punitive damages. The total judgment against Harrison was a staggering $1.6 million. Moreover, Judge Vance took the extraordinary step of referring the case to the Orange County District Attorney's Office for criminal prosecution on charges of grand theft and forgery. Maria, who had sat silently throughout the proceedings, burst into quiet sobs, clutching my hand tightly. It was a mix of relief, vindication, and the profound sadness that this had ever had to happen. The consequences for Robert Harrison were swift and severe. His assets, including the boat and a substantial portion of his investment portfolio, were immediately frozen to satisfy the judgment. Within weeks, the district attorney filed criminal charges and Harrison was arrested. He ultimately pleaded no contest to grand theft and forgery, serving a 2-year prison sentence and facing years of probation upon release. A new professional executor was appointed by the court, who efficiently finalized the estate, and Maria received her full inheritance, including the punitive damages, several months later after Harrison's liquidated assets covered the judgment. This case taught me yet again the insidious nature of betrayal, especially when it comes from individuals we place our utmost trust in. Robert Harrison was not a stranger. He was a friend, a confidant, someone Elena herself had chosen. The lesson here is profound. Trust, especially in matters of significant finance and inheritance, should never be blind. For anyone watching, here are the crucial warning signs to watch for if you are a beneficiary or have entrusted someone with an estate. Lack of transparency. If an executor is evasive, fails to provide regular accountings, or refuses to share bank statements, consider it a major red flag. Unexplained delays. While probate can be slow, undue or unexplained delays in distributing assets or providing updates are suspicious. Vague responses. When questioned about estate finances, if responses are vague, defensive, or dismissive, it's time to dig deeper. Self-dealing or personal use of funds. Any indication that the executor is using estate funds for personal benefit, new cars, vacations, home improvements, is an immediate call for legal intervention. Refusal to provide documentation. An executor must provide documentation. If they refuse, that's a clear breach of their fiduciary duty. My professional insight, after all these years, is that desperation, greed, or simply an inflated sense of entitlement can corrupt even the most outwardly respectable individuals. The temptation of unchecked funds, particularly when the original owner is no longer here to object, can be overwhelming for some. Always remember, oversight is not a sign of distrust. It's a necessary safeguard. If you're facing a situation where you suspect an executor or trustee is not acting in the best interest of an estate or trust, don't wait. The longer you wait, the harder it becomes to recover stolen assets. Seek legal counsel immediately. Months after the verdict, Maria Rodriguez visited me. She was no longer the broken woman who first walked into my office. With the recovered funds, she had paid off her debts, secured her financial future, and most touchingly established a small scholarship in her mother's name at her old elementary school. She finally had peace, and her mother's legacy was not only restored but amplified through her generosity. This is why I do what I do. It's not just about winning cases. It's about protecting legacies, fighting for justice, and helping individuals navigate the often treacherous waters of grief and betrayal. I've got plenty more stories of family feuds, unbelievable legal battles, and the hidden depths of human nature right here on the channel. Drop your questions about executor duties or probate fraud in the comments below. Make sure to subscribe and hit that notification bell so you don't miss them. Until next time, stay vigilant and protect your legacy.